Welcome to Real Estate School. Today's topic, real estate agency. We're going to be discussing some of the most important questions you need to know for your state's real estate licensing exam. So let's get started. Let's get started with our first agency question that you'll most likely see on your real estate licensing exam. In a real estate transaction, the term fiduciary typically refers to A. The sale of real property. B. The people who gave someone else the legal power to act on their behalf. C. The person who has legal power to act on behalf of another, or D, the agent's relationship to the principal. The term fiduciary typically refers to D, the agent's relationship to the principal. The relationship of the agent to the principal involves care, obedience, loyalty, disclosure, accounting, and confidentiality, which can be remembered by the acronym COLD-AC. A fiduciary relationship. A person with legal power to act for another is an attorney, in fact. Most real estate agents do not have such power. Question number 2. Designated agency is most likely to occur when A. There is a client buyer and a customer seller. B. The seller and the buyer are represented by different companies. C. Both the buyer and the seller are customers. And D. The buyer and the seller are represented by the same company. Our answer is again D. The buyer and the seller are represented by the same company. Designated agency is a process that accommodates an in-house sale, in which two different sales associates of the same broker are involved. The broker designates one sales associate to represent the seller and one sales associate to represent the buyer. Keep in mind, designated agency is a form of dual agency. In this case, the broker remains a dual agent. The broker is representing both parties. Thus, the written permission of both parties involved is normally required. Our third agency question that you'll most likely see on your real estate licensing exam. The agent's obligation to use skill and expertise on behalf of the principal arises under which of these common law duties? A. Care. B. Obedience. C. Loyalty. Or D. Disclosure. Our answer is going to be A. Care. Care requires skill and expertise. Obedience requires following lawful instructions. Loyalty is putting the client's interest above the agent's, and disclosure refers to material defects of the property. You do very well to know those duties. Question number 4. Which of these situations would least likely trigger the need to discuss agency relationships? A. A home show when somebody stops by the booth and picks up marketing materials. B. A listing appointment where you inspect the property and start to learn about the seller. C. An open house when a prospective buyer begins to express serious interest in the property. Or D. In your office when a man comes in off the street and asks to look at one of your listings. Our answer will be A. Of these options, the home show is least likely to be considered substantive contact where confidential information is likely to be shared. Question number 5. A licensee most likely performs ministerial acts for her A. Broker, B. Client, C. Customer, D. Fellow licensee. Our answer will be C. Ministerial acts are those things that a licensee does for a customer that do not rise to the level of agency representation. We work for a client. We work with a customer. Question number 6. Our next agency question you'll most likely see on your real estate licensing exam. James is a licensee who works for broker Mary at ABC Realty. As such, James would be considered what type of agent of the broker? A. James is a general agent. B. James is a special agent. C. James is a universal agent. Or D. James is not an agent of the broker. Well, I'm sure broker Mary considers James to be a very special agent, but that's not our answer. Our answer is A. James is a general agent. A real estate licensee is a general agent of his or her broker. The broker, the principal in that relationship, gives general authority to his or her agents to conduct real estate business on his or her behalf. An agency relationship may be involuntarily terminated for which of the following reasons? A. Death or incapacity of the broker. B. Mutual consent. C. Full performance. Or D. Renewal of the agent's license. Well, of course, the key word in this question is involuntarily. Involuntary termination of an agency relationship can occur upon death or incapacity of the broker. Death of the broker or the client would terminate an agency relationship. Our next question that you'll most likely see on your real estate licensing exam, question number 8. The duties of an agent acting as a facilitator are most similar to those of A. Subagent, B. Single agent, C. Dual agent, or D. Implied agent. A facilitator is also referred to as a non-agent because we're not representing either party. This is a situation where your neighbor wants us to help them sell their home by owner. They're going to do the marketing, they're going to find the buyer, and they'll negotiate all terms with the buyer. And the agent will come in and work with the buyer and seller as customers by putting the transaction in writing, what the buyer and the seller have agreed to, making sure the buyer and the seller get through the inspections, make sure all proper disclosures are made, and make sure all documents get to the closing agency. A facilitator. This is much the same as a relationship in a dual agency relationship. In a dual agency relationship, the agent has to act as an independent contractor. They tell us this is the only fair way to perform a dual agency transaction. Simply, the one agent backs out of the transaction, sends the buyer and the seller to get dinner one night and to work things out on their own. Price, closing costs, closing date, does the refrigerator stay with the home or not? The agent cannot be involved as a dual agent, which is the same as a facilitator, also known as a non-agent or independent contractor. Our next question number 9. A person who is designated by the principal in a broad range of matters related to a particular transaction or activity is A, facilitator, B, special agent, C, designated agent, D, general agent. Our answer is D, general agent. A special agent is given limited authority for a limited time. A general agent is given broad authority in a specific circumstance. A property manager is typically a general agent for the owner, as are most real estate sales associates for the employing broker. Question number 10. Which of these statements could be negligent misrepresentation? A. The uneven floors just means that the building dates to colonial times. B. I think these low doorways are a charming part of the Cape Cod style. C. The simple design is uncluttered and can give you many possibilities for decor. D. The size of the bedrooms makes them wonderfully cozy and perfect for your children. Our answer is going to be A. Presenting an opinion is acceptable so long as it's not presented as a fact. Uneven floors could mean a latent defect, such as a rotten supports. Thank you for attending real estate school. We'd like to hear from you. If there's a subject you would like us to discuss, let us know in the comments. Also, click that bell and hit that like button so we can notify you of our upcoming videos. Thank you.